So today's lecture is on the court system and the system of judicial selection in Texas. And what I want to do is just go over the different types of courts that there are in Texas, what the requirements are to serve on those courts, how the election process works for most of these courts. And then I'll conclude with several short videos from a former Supreme Court Justice named Wallace Jefferson, talking about what he thinks is wrong with our system and how he would recommend fixing it. And there will be several questions for review based just on his videos on. But the videos are embedded here so you can see them on Canvas afterwards if you miss anything during the lesson. So, first of all, we have what has been referred to as judicial federalism, and what that means is we have a two-court system. So here in Texas, there are two kinds of courts. There are state courts and federal courts. So if this were a U.S. government class, I would talk about the federal courts. There are United States district courts in Tyler and in other parts of the state. There is a U.S. appellate court or circuit court of appeals in Louisiana that hears appeals from Texas. And then there's the U.S. Supreme Court. And many Texans use those federal courts to dispute, issues, cases involving federal law or the Constitution. Here, though, we're going to focus mostly on the state courts. So we have this system on the right-hand column, where you have a state Supreme Court, and in our case, actually, two state Supreme Courts. You have 14 state appellate courts in Texas. You have numerous state trial courts and even other kinds of courts as well. And these are the kinds of courts, these state courts are the ones that you're most likely to use in your lifetime here in Texas. These are the cases, the courts that handle things like divorces, child custody disputes, most of your lawsuits against other citizens are going to be handled in state courts as well. So there are two kinds of cases, broadly speaking, civil cases and criminal cases. So civil cases handle disputes between citizens. So if an individual believes that they have caused or have been injured by someone else, they'll file a civil suit. And so in a civil suit, the style will say something like, John Doe versus Jane Roe, right? The titles are the names of the individuals who are involved in the lawsuit. The standard of proof in a civil case is preponderance of the evidence. What does that mean? 51% of the evidence, or 50.1% of the evidence. A majority of the evidence decides who wins. So if a judge or a jury hears this case and decides, well, we think it's 49% likely that Doe is correct, but we think it's 51% likely that Roe is correct. In other words, it's slightly more likely than not that her version of events is the true one, then she wins the case, right? Now, I said just a second ago, a judge or a jury may decide the case. The default is a bench trial, which means a trial by judge. The phrase bench trial means judge. And a jury trial, of course, means jury. But one of these litigants, or both, could request a jury trial. And usually there's some sort of a period, like you have to request it at least 30 days in advance or something like that to give the court time to prepare for a jury trial. Now, in this case, in these civil trials, the winning party usually is compensated in the form of money. Or it could be an order for the other party to do something. Like in an eviction lawsuit, the order might be get out of the apartment or the house that you're in, or let the person back into the house or the apartment that they're renting. But usually the winner is going to get money in compensation, and the loser is going to pay. In civil cases, no one goes to jail. You don't go to jail for losing a civil case. That's one of the key distinctions. That and preponderance of the evidence are probably the two key things to remember about civil cases, that they involve money and that you win with the preponderance of the evidence. So some examples of civil cases include lawsuits over money, property, damages, disputes like that. Also, family law cases are civil cases, marriage, divorce, child custody, etc. Criminal cases involve violations of the law. So these are crimes against society or the state, and representatives of the state prosecute individuals. So here, the case might be called something like Texas versus Jane Roe. So Texas is accusing her of breaking some law in Texas, right? Some criminal law. And Texas has to prove that she broke the law beyond a reasonable doubt. Beyond a reasonable doubt. I can't give you a percentage, whether that's 75%, 99%, what, but it's much more than just a preponderance of the evidence, right? So if a judge or a jury hears this case, they decide she's guilty, whatever it might be, drunk driving, burglary, murder, they decide she's guilty if there's no reasonable doubt that she did it. Not unreasonable. You could imagine all sorts of crazy fictional scenarios, but if there's no reasonable doubt that she committed whatever crime she's accused of, then the state wins the case and she's guilty. Now, what kinds of punishment? It could be a monetary fine. It could be imprisonment, jail or prison, or it could be both. Now, a little bit about decision making by the courts. So courts resolve conflicts by interpreting and enforcing existing rules and laws. One basic rule is that individuals, in order to appear before a court, must have standing. So courts do not deal in hypothetical or imaginary controversies. The case must involve real controversies between two or more parties, and someone must have suffered real damage. Let me give you a very simple example of this. So standing means the party must have some direct involvement in the outcome of the case, in the incidents that gave rise to the case. Now suppose that I witness something. I witness John Doe damaging the property of Jane Roe. And so I say, I'm going to sue you. I, John Powell, am going to sue John Doe because I saw him damage the property of Jane Roe. What is the court going to do to my lawsuit? They're going to throw it out. Dismiss it. Yeah. Mm-hmm. Because I don't have standing. They're going to say, obviously, there may be a very valid complaint here, but the actual victim is the person who must bring it, not some other bystander, right? So strict procedural rules determine when and how to present facts and arguments. Generally, a court's decisions only affect a case that the court is considering, but decisions can also serve as precedents for parties in the future with a similar dispute. That's what we mean by stare decisis that I wrote here on the slide. So stare decisis is Latin for something like let the decision stand. And this is an old principle in our legal system that goes back hundreds and hundreds of years, all the way back to England, maybe 1,000 years ago. And the idea is simply, once a judge or a jury has heard a case involving a certain set of facts, if another case comes along before that court involving identical sets of facts, the judge should resolve it in the same way. So if the judge hears a certain series of facts in a John Doe versus Jane Roe case, and then 5 years later, I don't know, Jim Brown sues Joe Green, and the judge says, you know what? This case involves the same law that this case involved. And this case has the same circumstances that this case involved. Then, however I decided this case, the first case, suppose I decided that the plaintiff wins the first case, then the plaintiff should win the second case as well, right? For consistency. We shouldn't have different outcomes in cases that involve the same facts and the same legal disputes. So that's stare decisis. So this is the principle that court decisions depend on previous rulings of those courts and sometimes other courts for their precedents. I want to talk to you about two types of juries, broadly speaking, that you need to be aware of. Grand juries and petty juries. First, a grand jury. And this has to do with criminal law, just to be clear, criminal law. So grand juries determine if a person will be charged with a crime. Most grand juries serve for 6 months. Texas uses both grand juries and administrative hearings. This is an administrative hearing is a hearing before a judge who decides if a person must stand trial, and sometimes they can be used in place of a grand jury. A citizen can waive his right or her right to review by a grand jury and can ask that for an administrative hearing instead. Here's the main idea. Grand juries are supposed to serve as filters to prevent arbitrary actions by prosecuting attorneys. However, there's some debate about whether or not they are currently performing that function the way they were intended to. So I gave you your hypothetical Texas versus Jane Roe. So Texas accuses Jane Roe of violating a statute, of committing a crime. The idea is that before a prosecutor from Texas can drag her into court and accuse her of the crime, and she will be at risk of going to prison or having to pay a fine, first, the prosecutor has to take the evidence to a grand jury and convince the grand jury that there's enough evidence to warrant a trial. Does that make sense? So the grand jury is like a gatekeeper. If the prosecutor shows the grand jury, this is all the evidence we had that Jane Roe was driving drunk, for example, and the grand jury says to itself, well, you don't have any evidence at all, this is not enough, then they can just say no right there, and there's no trial before a judge and all that. She's not at risk of going to prison, it just gets stopped in its tracks. But like I said, there's some doubt about whether grand juries are continuing to perform this function the way they were supposed to, because they almost always just follow the advice of the prosecuting attorney. Prosecuting attorney says, we think she drove drunk, and they just rubber stamp it, and it goes forward to a trial. That's the way many critics think that it's happening. So some key points. During grand jury proceedings, the accused may not have an attorney present during the hearing. And however, during an administrative hearing, which is before a judge, not a jury of any kind, the attorney is present and can protect the accused. So there might be some value in preferring an administrative hearing. If the grand jury says okay, and then the prosecuting attorney decides, yes, we're going to accuse Jane Roe of this crime, then you go to the trial in front of either a judge or a petty jury. And the petty jury is the jury that you all see on TV in TV shows about lawyers and detectives and that sort of thing. This is where they argue in front of the judge and they call witnesses, and there's a defense lawyer and a prosecutor and that whole big show. is in front of the petty jury. So the petty jury determines the guilt or innocence of a person during a trial. The grand jury didn't determine the guilt. All the grand jury said was there's enough evidence to have a trial. The petty jury decides whether or not the person is guilty or innocent. A jury pool can be randomly selected from, it may be randomly selected from voter registration lists or from a list of licensed drivers. In both criminal and civil cases, the defendant has the right to a trial by jury, but may waive this right and let the judge decide the case instead. Now, most legal criminal disputes don't go all the way to the petty jury. In Texas, there are more than 1 million criminal cases filed in county courts each year. 1 million cases, criminal and civil. There are more than 1 million cases filed in county courts each year. Fewer than 5,000 result in jury trials. So most legal disputes, whether criminal or civil, don't go to a jury trial. Most cases that are criminal cases end in a plea bargain and never go to trial. A plea bargain is when the accused agrees to plead guilty in exchange for a lesser sentence, and the judge can accept or reject that agreement. A few months ago, I saw an interesting case in Florida. There was a drunk driver that had killed somebody. No, not killed somebody, left them paralyzed, I think. And this was a repeat drunk driver. She had been caught driving drunk multiple times. And the prosecutor made a plea bargain where she would get probation, and the judge refused it. Said, no, you have to have a trial. This isn't acceptable. And so judges can do that sometimes. It doesn't happen. Most of the time, I think they accept the plea bargain, but they can reject it if they want. So these are the different kinds of courts in Texas. Texas has several levels of trial courts and appellate courts. This is from September 1, 2020. I haven't checked if it's still up to date, but it's pretty close to up to date. They create new justice courts and new municipal courts a lot. So every couple of years I have to update my chart. But the main idea is we have, for trial courts, justices of the peace, municipal courts, county courts, district courts, and some special courts like probate, juvenile, and domestic relations courts. We have appellate courts. We have 14 courts of appeal in different regions or districts around Texas. So there are 14 different districts with their different courts, and there are about 80 justices on those 14 courts. We have 2 Supreme Courts, or 2 courts that are the highest appellate courts. The Supreme Court of Texas handles civil cases, no criminal cases. The Court of Criminal Appeals handles, criminal cases. So a death penalty case, for example, would be in the Court of Criminal Appeals. It would never be in the Supreme Court of Texas because it would only handle civil cases. The information here is pretty accurate. District courts have original jurisdiction in civil actions over $200, divorce, title to land, contested elections, juvenile matters. So these are trial courts. County level courts, you have constitutional county courts, statutory county courts, and statutory probate courts. The constitutional county courts in most counties are not really judicial courts anymore. They're more executive governments. So for example, the county judge in Dallas is more like the county mayor or the county governor, and the county judge in Houston the same way. I don't know about Henderson County. But the statutory county courts hear trials in civil and criminal cases, and they hear appeals from lower courts, from justice courts and municipal courts. And the justice courts and municipal courts are trial courts. They have all kinds of trials for small claims disputes, landlord-tenant disputes, traffic and other misdemeanor crimes, and things like that. So a little bit more about trial courts. Their jurisdiction is limited to a geographic area, such as a county or a district. Only one judge presides over trial court, and each court is considered a separate court. Citizens of the county can serve on juries and as witnesses during trials. And probably the most important function of the trial court is to establish the facts of a case. And usually, once the facts of a case have been established in a trial court, they are not reviewed in an appellate court. So at the Supreme Court level, you don't get to re-argue the facts, because the trial court already decided those. An appellate court is centralized, often at the state level, but I did say there are 14 regional central courts, regional appellate courts. More than one judge presides over an appellate court. So, at the Supreme Court of Texas, there are 9 judges. The Court of Criminal Appeals, there are 9 judges. The courts of appeal, the 14 regional courts of appeal, there are 5 each, about. Now, at the appellate court level, there is virtually no citizen participation, meaning there are no witnesses, there's no jury at the appellate court. Judges make the decisions. And appellate courts decide disputes over the law, not disputes over the facts. So, if Texas accused Jane Roe of hitting somebody and committing assault, whether or not she did that act would be decided at the trial court, and then the appellate court wouldn't touch that issue again. Right? The appellate court would deal with legal disputes only, like did the police violate her constitutional rights? Or did the trial judge violate some procedural right that she has during the trial? So those are the kinds of questions that the appellate court answers. Okay, one important point about the appellate court: all death penalty cases are automatically appealed to the Texas Court of Criminal Appeals. So if someone is given the death penalty as the punishment in a district court, there is automatically an appeal to the highest court in Texas, the Texas Court of Criminal Appeals. Now, there are municipal courts that are created by statute. So these are courts at the city level. They can be either appointed by the city councils or elected. Most of them are appointed. Some municipal court judges have to be attorneys, others don't. It depends on the area. And there's a concept here. Some municipal courts are courts of record, and some are not. And what I mean by a court of record is that it keeps a transcript of the hearings. If it keeps a transcript of the hearing, then the hearing can be appealed to a higher court, a county court. If there's no transcript, you can still appeal, but you get a brand new trial at the higher court. And that brand new trial is called a trial de novo, which just means new. So most municipal courts do not keep transcripts. They do not keep records of the testimony in their trials. So any county court that hears a municipal court case on appeal just has a brand new trial. Municipal courts usually often hear cases involving violations of city ordinances, most often traffic violations, and they can hear other misdemeanor offenses. And municipal judges can issue arrest warrants. Justices of the peace are also very common courts. The interesting thing about JPs, they're not required to be attorneys. They do not keep a record. There's no court record in the JP court. So you can appeal a JP decision and you get a trial de novo at the county court level. Give you a simple example. Evictions are almost always, or maybe always, first done at the justice of the peace level. So suppose I'm a landlord and my tenant won't pay rent. I go to the justice of the peace and I sue the tenant for an eviction to make them leave the apartment or the house that they're not paying rent on. At the justice of the peace, we have a trial. If I win the trial or lose, whoever loses the trial at the justice of the peace level can appeal to the county court level. And when we get to the county court level, we just have a totally new trial, just brand new, as if the JP court never happened. Right? And the reason we do that is there's no record of our testimony in the JP court to review. So it has to be a brand new trial. So JP courts can issue search and arrest warrants. They hear minor criminal cases like traffic tickets. They also serve as small claims courts. This is an interesting part of JP courts. If you need to sue somebody for anything less than $10,000, a justice of the peace court is the best place to do it. It's the best place to do it because you don't need a lawyer in JP court. You can just argue your case in front of the judge, and he or she will decide, based on your testimony versus their testimony. Municipal courts do not serve as small claims courts, only justice of the peace courts. The jurisdiction is limited to $10,000 or less, so if you need to sue your neighbor for $50,000, you have to go to the county court or district court. JPs can form marriages. They charge a fee for doing that, and the fee they get to pocket. That's their own income, extra income. Municipal court judges have tried to get that power in Texas and have failed. The JPs have managed to keep it for themselves. So I already kind of mentioned this. There are two main kinds of county courts: constitutional county courts and county courts at law, or statutory county courts. So county courts at law are created by statute, often in large urban counties like Dallas, Harris, Travis County, and Austin, because the county judge in those places is basically just a politician and not a judge. And so the county court at law hears actual civil and criminal disputes. They hear intermediate civil and criminal cases. Most of the criminal cases they hear are misdemeanors. And I've said this before, they also serve as appellate courts for JP and municipal court decisions. District courts hear major criminal and civil cases. And there's some overlap between district courts and county courts, so some cases could be heard in either court. I'll give you a simple example of that. A divorce in Smith County, for example, could easily end up either in a district court or a statutory county court. But suppose somebody is being accused of capital murder, right? Meaning they're going to get the death penalty if they lose. Is that going to be in a county court or a district court? District court, yes. Because that's not a misdemeanor, right? That's a major crime. Major crimes are going to go to the county courts. Appellate courts, I've mentioned. There are 14 courts of appeal with 80 judges. And these judges are elected by the districts that they represent in that court of appeal. So this November, there will be elections for appellate court judges for whatever district we're in. Are we in the 12th or the 6th? Something like that. So they hear all civil appeals cases and all criminal appeals except the death penalty, which goes straight to the top, straight to the Court of Criminal Appeals. The Supreme Courts, these pictures are outdated, but most of these people are still there. Like I've said earlier, there are 9 people in the Supreme Court of Texas. They hear the civil cases. There are 9 people in the Court of Criminal Appeals. They hear the criminal cases. There's a chief judge or chief justice of each one, and that is an elected position. So you run statewide for the job of chief justice of the Supreme Court or the Court of Criminal Appeals. There's a process in Article 15 of the Texas Constitution for removing a judge. The Texas Supreme Court can remove a judge for partiality or oppression or official misconduct, or if the judge's habits render him unfit to hold office. But also, by a 2/3 vote of the Texas legislature, the governor can remove a judge for neglect of duty, habitual drunkenness, or oppression in office. And a 2/3 vote of the state senate can remove a judge in the impeachment process. And in addition to all of that, county judges and justices of the peace can be removed by district judges.